My friends say that I'm an indecisive person. I can't make a decision. For me, there are too many variables to consider, and this can confuse me and stifle my progress. But this is nothing compared to how complicated a natural system such as the environment is. It is impossible to predict with any certainty how this system will evolve and react to changes. And so how can we protect something such as the environment when the data we are dealing with is so uncertain? How can the data be used in a meaningful way? The precautionary principle, developed as a means of transforming scientific uncertainty into data that can be used in policy making and legislation. There is no one definition of the principle, but the most recognised is probably that of Principle 15 of the Rio Declaration. Where there is a threat of damage, uncertainty should not be used as a reason not to act. At the EU level, the principle is enshrined in EU treaty law. The European Commission drafted a communication paper on the principle in order to give clarity to its application. The paper isn't binding, but it gave broad guidelines as to how to apply the principle, and responsibility was given to the Court of Justice of the EU to define the principle more precisely. The paper placed science at the core of the principle. So how does the court approach science and scientific evidence in the application of the principle? And what impact has its interpretation had on the use of the principle and the science that informs it? In my research, I've looked at decisions of the CJEU when dealing with the principle in the general area of environmental law. And in the following few minutes, I'll outline some of my findings. The court has recognised that scientific evidence is an important procedural guarantee. The communication requires the scientific data to be reliable and available. The court has interpreted this as requiring the best scientific information available or data based on the most recent results. It has given examples of how these criteria can be met, such as by using peer-reviewed data or established methodology, but these aren't infallible. There is often subjectivity in science and bias, especially when publishing, and using the most recent available results might not reflect what information is needed by society. It is a difficult area to define, but these terms are quite vague and bring no clarity to the definition of the principle or to the type of data required to apply it. The communication specifically refers to taking due account of minority science and contradictory evidence indicative of uncertainty. EU institutions rely on opinions of scientific advisory bodies who have to take minority science into account, but the EU institutions don't have to follow these opinions. So minority science might be taken into account by the advisory bodies, but might not make its way into the assessment of the best precautionary measures. Scientific data should be objective and independent. EU institutions usually request scientific committees consisting of independent experts to carry out the scientific evaluations, but, similar to minority evidence, the EU institutions are not bound to accept these opinions, and so decisions are being made without an independent, objective scientific basis. So what does all this indicate? The court does place importance on the scientific element of the principle, but it doesn't follow this through. There is no clarity as to the type of science that should be used in the application of the principle. There is no coherent approach, and this has weakened the role of science. And more importantly, it has weakened the application of the principle, rendering it ineffective and unable to fulfill its role in guarding society and the environment against potential risks. So how can we rectify the situation? We must recognise the importance of scientific facts in the application of the principle and use the scientific data in a consistent manner. At a judicial level, the facts should be assessed similar to any other evidentiary requirement. And we need a more collaborative approach between the scientists and the legislature. The environment is a complex system, and we are all a part of it. The principle, if used effectively, can help us move forward and tackle the problems of today. But we need a collaborative approach, with science at the core.